I want to introduce Judge Dwyer. Good morning. Judge Dwyer, as you know, was one of Bob's regular speakers here for many years as part of the Pitler program. He's a judge of the New York Court of Claims and acting justice at the Supreme Court, where he has been assigned to Brooklyn and Manhattan. They fight over him all the time. And prior to taking the bench, Judge Dwyer served in numerous capacities, notably as the chief of the Appeals Bureau for the New York County DA's office for 24 years. He served as counsel to District Attorney Morgenthau and eventually served as Chief Assistant District Attorney. Judge Dwyer is a co-chair of the New York State Justice Task Force, a prior chief of the American Bar Association's Criminal Justice Standards Committee, and a former chair of the New York State Bar Association's Criminal Justice Section. Please welcome Judge Dwyer.
Good morning to you all. I'm here to talk about New York's right to counsel. Now, police officers these days know all about Miranda because they watch TV just as we do. And so they know they've got to read those rights, and at least they testify that they read those rights. But the police officers haven't got the right to counsel down quite so well. It doesn't appear on Law and Order very often. And so it's important that lawyers understand the right to counsel, and especially New York's right to counsel. New York's right to counsel has as its special component the indelibility of the right. And we'll talk as we go through the outline about how that indelibility plays out in several different contexts. The federal rule does not remotely have that kind of indelibility. And indelibility simply means that once the right to counsel attaches, you pretty much, under all scenarios in New York, can't be questioned by the police. That's not true under federal law, but it's true under New York law. The New York law goes further than federal law, even though, as you can see from page 1 of the outline, the right to counsel in New York hangs on a pretty narrow thread. The right to counsel is based on the New York constitutional provision that in any trial, in any court whatsoever, the party accused shall be allowed to appear and defend in person and with counsel as in civil actions. And that's all it says. Now, it's pretty hard to see that as a ringing endorsement of a criminal defendant's right to counsel. And so all the rules that I'm going to talk about today are pretty much just the way the Court of Appeals has felt about things. That's not a criticism, because you may find that what the Court of Appeals has said in these cases is absolutely sensible. But it is true that this is judge-made law, common law in New York, in the best sense of the word. Now, I want to start with a case that has no dramatic significance. It's People against Grice. And Grice is in there just because it announces several of the principles I'm going to talk about today, including the fact of the counsel right in New York being indelible. And once again, what it means is that once the right to counsel attaches, that's pretty much it. There are cases that deal with extreme scenarios. Two of them are West and McLean. In West, the defendant was charged. The defendant had an attorney. 3 years passed without anything going forward. The police got some new information. Actually, the defendant wasn't charged. His attorney had appeared with him at a lineup, but the attorney had entered the case. 3 years later, defendant's out of custody. One of the participants in the crime wants to cooperate with the police because he's charged with something else. And so he wears a wire and goes and chats with West undercover. No notice is given to the attorney. The confidential informant is certainly a police agent in that scenario. And the DA's office, including me, argued that the right to counsel no longer attached because the defendant was out of custody, because 3 years had passed, no reason to think the attorney was still involved in the case, and the Court of Appeals disagreed with us. The Court of Appeals said, hey, when we say indelible, we mean indelible. Once that attorney entered the case, even 3 years later, when everyone thought the case was dead, you can't talk to the defendant without having the attorney present. Different scenario arose in McLean. In McLean, the police did not just put a CI onto defendant or otherwise act surreptitiously. They went up to the lawyer and they said, "Do you still represent the defendant?" And the lawyer said, "No, go ahead and talk to him." That is not what most lawyers do who have represented defendant. But the lawyer had represented the defendant on one case on which the defendant was given 12 years. The defendant was given a chance to cooperate to work down the sentence. The police determined that he had lied during the cooperation. The lawyer had represented him on the first case, the 12-year case, and had been involved in the negotiations about cooperation, but a second case had never been brought against the defendant. So the lawyer was in the ballpark, which is why the police thought they had to talk to him. But again, the lawyer said, "Not me," and the confession that was eventually taken from the defendant was found to be admissible. One more general note. Under People against Rosa, the burden of proof is placed squarely on the defendant to prove that he has a lawyer at the time the police question him. If there are factual issues, as of course there so often are in cases like this, if there are factual issues, the defendant has to show that he was actually represented or that for some other reason the right to counsel had attached. There is an emergency exception, and a case like Crom is always the kind of case that's going to create an emergency exception. A guy walks into a house with a rifle, holds the two men there at bay with the rifle. He's masked and he's totally silent. The wife of one of them, or the daughter of one of them actually, comes home and he kidnaps her. And nobody knows where he went, but he calls up later with a ransom demand for $1 million. And one of the people at the house recognize his voice. It's somebody he's known for quite a while. So the police eventually go out and arrest the guy. And he says, "Well, I didn't do it, but I know where she is, kinda, sorta. And I'll tell you where she is if you give me $400,000. And the police said, "No, we're not going to give you $400,000. And he said, "Well, how about $100,000? And $10,000 for expenses." The police said no to that too, but eventually took statements from him that were highly inculpatory, and he eventually led them to where he had buried the coffin with the young lady in it. And the confession or the admissions were found to be admissible because of the emergency. Now, unfortunately, the victim was dead by the time he got there, but still, he ended up having a confession that caused him to be convicted for her murder. People against Dahl was another weird case, but not quite as weird as Crom. In Dahl, the defendant is walking around in what a hunter would chop up a deer with, that kind of an outfit to keep from spattering blood all over his clothes. And in this case, he had a lot of fresh blood on his clothes. And ultimately, the police figured that he had assaulted someone, and as in Crom, forgot about the right to counsel and just tried to figure out where the victim might be. No indication that the victim was in the kind of trouble that the woman was in the Crom case, but the same emergency exception applied, and the court was perfectly willing to overlook the fact that the normal right to counsel principles were not honored. And finally, my first typo in this outline comes with People against Colwell, which talks about the effects of the appellate rights in a particular case on the right to counsel. This is a Rogers case, and we'll see what Rogers is all about down below. But basically, the defendant had a lawyer on case B. He was appealing case B. I should have said appellate prospects on case B do not matter. I accidentally slipped in an A there. My geometry was that bad too. But in any event, the fact that you've got an appeal with a lawyer on case B does not create any kind of a right to counsel on case A. That is true, said the court, even though it's conceivable that a defendant who is interrogated would give up information that would hurt him at any retrial on case B. The court simply thought that the appellate representation was too attenuated, and the indelible right to counsel does not apply in that situation. So, what does cause the right to counsel to attach? And I've talked about several triggers that create the right to counsel in New York. And the first one of them is perhaps the simplest. Once the people file an accusatory instrument against a defendant, the police cannot talk to him without the lawyer being present. People against Samuels make sure to apply that rule where a felony complaint is filed. The police had filed, or the people had filed a felony complaint because they wanted to get an arrest warrant. And in New York, to get an arrest warrant, you've got to have a complaint filed. And so the right to counsel attached when they got that arrest warrant. Now, that scenario, this is one area where the police are up on the rules. That scenario creates a dilemma for the police. If they get an arrest warrant for the defendant and therefore overcome any patent problems with arresting the defendant where they most logically will find him, in his home, they won't be able to talk to him after they find him. Instead, the police have invented this thing, I'm sure most of you have heard of it, called an I-card. And with an I-card, the police are telling one another, one of us has probable cause to arrest this guy. If you see him, arrest him and bring him to the officer with the probable cause. Now, that works, except it doesn't work if the defendant's in his home. And again, that's the most logical place to find the defendant, because patent is satisfied only by an arrest warrant and not by this little police device called an I-card. So again, the police are in that dilemma. If they use the I-card, they can't go into the home. If they use a warrant, they can go into the home, but they can't talk to the defendant. People against Ridgway simply says that the existence of a federal accusatory instrument and a federal arrest warrant will have nothing to do with the New York's right to counsel. We've segmented our right to counsel, and it applies to New York actors. What the feds do under their constitution has nothing to do with the New York right to counsel. One might think that's a little odd, since the admissions in a case like Ridgway will be introduced at a New York state trial, but that's the rule. And People against Hopkins is a case where arraignment delay was involved, and the court ended up saying, look, it's the filing of the instrument, that's the bright line. The filing of the instrument creates the right to counsel, and the simple fact that the DA or the police delay a little bit in filing that instrument doesn't violate any of defendant's rights. Next we get to Trigger 2. Trigger 2 means simply that a lawyer has entered the case, but that one is not quite as simple as Trigger 1. I don't know if many of you are old enough to remember Kojak. I am. And there was a two-part beginning to Kojak, a two-part pilot, which was, I thought, very effective. It was about a real case in New York. It was about the murder of two young career girls in their 20s in their apartment during a burglary, their apartment being on the Upper East Side. The tabloids grabbed this for all it was worth, and the papers were full of this case. Eventually, the suspicion focused on a guy named Robles. Mr. Robles had an attorney. The attorney was with him at the precinct and eventually went home. The police decided they wanted to talk and, of course, break this very public case. The case went up through the courts, and the Court of Appeals said, gee, the right to counsel isn't indelible. Well, hard cases make bad law. People against Hobson came back a number of years later and overruled the pilot of Kojak. In Hobson, the court simply referred to Robles and one other case decided along the same lines. It simply called them errant footsteps and said that errant footsteps are not binding on us. The New York rule is that the right to counsel is indelible. And Hobson, to this day, stands for what it said and has not been overruled. You'll see where it's defined a little bit, cut back a little bit, but Hobson still states the general rule. Once the attorney enters the case, that's it. Well, what does it mean for the attorney to enter the case? And here's my second typo in this outline. I don't know how the site for Augustine or Augustine got to be what it is there. It's really 89 AD 3rd, 1238, 3rd Department of 2011. In that case, the criminal court had designated an attorney for assignment to the case, but there was a major factual issue about whether he had actually entered the case. Remember, the defendant has the burden of proof on the factual issues, and nobody could get a handle on just when he entered the case. And the third department held that it is actually the entry that creates this Hobson right, and not simple assignment, not simple paperwork on the part of the courts. People against Arthur is a classic. In Arthur, the defendant had been represented in several civil cases by an attorney. The attorney comes home after work, and this is a small town, so the attorney gets home by 6 o'clock. And he turns on the nightly news, and he sees that his client is being held for a serious crime. So he hurries up and gets in his car, and he gets to the only police station in town, and he knocks on the door, and he says, "I represent the defendant," and he entered the case. And the statements taken after his entry were found to be a violation of the Hobson rule, because all you have to do is tell the police, "Here I am, I represent him," and obviously the connection between this guy and the defendant was a real one. People against Pinzon is a more modern version of Arthur. In Pinzon, the lawyer knocks on the door of some precinct somewhere on Long Island, but it happens to be part of the same police department that was holding the defendant in a different precinct. The courts have said, the Court of Appeals in particular, of course, that that's good enough. You've put the police on notice. You don't know where the defendant is in a large jurisdiction. It's not like Arthur's one precinct town. And so when the police hear the knock on the door, that's it for Hobson purposes. They can't talk to the defendant anymore. Well, then we get to Carranza, which is that you at least have to call the right police department. In Carranza, the lawyer sent a letter to the DA's office and to the state police. At about the same time he was sending the letter, the local police arrested the defendant and took statements from him. And the court held that, well, you can't really charge the police with knowledge of the entry of counsel if counsel is telling the wrong people about his presence in the case. And so Mr. Carranza was out of luck. And then Grice, the case that I started with, Grice is a case in which Dad came to the precinct and said, "Gee, a lawyer is on his way." That was not good enough. Dad cannot create a right to counsel by himself. Until the lawyer arrived at the precinct, the rule did not apply. You can contrast a case that I didn't put on the outline for those of you who happen to represent juveniles or prosecute juveniles. People against Mitchell is 2 New York 3rd 272, 2004. And Mitchell says it is enough for mom to invoke the right to counsel on her client, on her child's behalf. And you can understand, of course, why juveniles would be treated differently. In the Mitchell case itself, the court said she didn't do that adequately, but if she had done it adequately, the right to counsel would have applied. The attachment of the right upon entry of counsel does not depend on whether the defendant is arrested or not arrested. This will be different under other triggers, but if the defendant comes to the precinct with a lawyer and he's not under arrest, that creates the right to counsel just as much as if he had been in a holding cell when the lawyer came. The rule applies. People against Anderson is a case in which the attorney called and had no connection to the defendant, to his family, or to his supporters. It would be as if a defense attorney walked into a local prison and said, "I represent all these guys." That doesn't work. You've got to have a connection to the defendant or, as I say, his family or supporters in order for you to be able to represent him in the Hobson sense. You also have an interesting contrast in Barakova and Lennon. In Barakova, the defendant's lawyer, unbeknownst to her, she had no knowledge, I should say the sister hired a lawyer when she heard that the defendant was under arrest. That lawyer came to the precinct, and the police said to the defendant, "There's a lawyer here who wants to represent you. He says the sister sent him. Do you want him? And she said, sure. Well, that meant the right to counsel attached. People against Lennon was very different. A lawyer who had represented the defendant in several civil cases came to the precinct and said, I want to represent the defendant. And she said, when asked about it by the police, gee, if I were going to be represented by a lawyer, that's the last guy in the world I would want to be represented by. And she refused his services, and talking to her was okay. And I'm getting the Barakova facts wrong now that I think about it. In Barakova, the police did not talk to the defendant and say that the lawyer had been hired by the sister. And so that meant suppression. The police didn't tell her. But obviously in Lennon, it was the opposite. The police did tell her, and because she said no, they at least salvaged the statements in that case. Trigger 3, an invocation of the right to counsel will cause the right to counsel indelibly to attach, mostly. People against Cunningham is simply a statement that says, if you are in custody and you invoke the right to counsel, that's good enough. But other cases, it may even be mentioned in Cunningham itself, but it certainly will be indicated in the big paragraph I've got down below leading into People against Davis. In those cases, the defendant is not in custody when he invokes, and he walks away and goes home, and the next day the police talk to him, and just a hypothetical scenario, they say, gee, would you like to talk to us now? The defendant, because he's not been subject to the coercive power of the state, is permitted to change his mind. So invoking on day one, going home, invoking on day one, going home, and then deciding to talk on day 2 is okay. The statements will be admissible. People against Ellis is a case where the defendant did enough. The defendant showed up at the precinct and said, my attorney, I know you're looking for me. My attorney is on the way. Is he here yet? No, he's not here yet. Well, he's coming, and we'll be happy to talk with you. And the police say, well, do you mind talking with us while we wait for the attorney? And the defendant says, no problem. And he starts to talk to them, and sure, he gives damaging admissions. The court said he had done enough to indicate that he thought the assistance of a lawyer was necessary in order for him to face the state. And so his talking about how the lawyer is on the way, when in fact the lawyer, I guess, was on the way, was good enough to invoke the right to counsel. People against Grice, the case I started off with, once again just states the rule baldly. And finally, here's the contrasting federal rule. Edwards versus Arizona says that this right, even though invoked by someone in custody, is not indelible under the federal Constitution, so that a defendant who is in custody and invokes can change his mind in federal custody, even though he can't do so in New York custody. And the long paragraph on page 4 is simply a contrast between the trigger 2 situation and the trigger 3 situation. If the attorney enters the case, People against Skinner, which I cited on the last page, People against Skinner says he can't change his mind afterwards. But if the defendant simply asks for an attorney, as I've just said, when he's not in custody, he can change his mind. The wild card, and I'm going way too fast. I'm going to have to talk. So I could give you some of my time if you want to talk about those other cases. The wild card will take a little bit of time to talk about anyway. A lot of appellate lawyers spilled a lot of ink in this neighborhood. Rogers is the initial case. Back in 1979, the court said that if the defendant is arrested on case A, he stays in custody on case A, he's got a lawyer on case A, the police cannot talk to him about case B. Pretty simple. If the defendant's at Rikers and you suspect him of something else, and he's got a lawyer on the case where he's at Rikers, the police cannot talk to him without involving that lawyer. Well, we could all live with that and understand that. And then came People against Bartolomeo, which was very hard to understand. In Bartolomeo, the police arrested the defendant on case B while he was out of custody on case A, on which he had a lawyer. Now, in that case, of course, the defendant could very well have said, I want my lawyer, or I want a lawyer, but he didn't. He talked, and the Court of Appeals decided that that violates the Hobson Rule. The Hobson Rule applies if you're in custody on case A, and it also applies if you are newly taken into custody on case B. All sorts of issues arose about what happens if the police don't know about case A, or what if they know about case A but don't know if he's got a lawyer or not. And the answer the Court of Appeals gave was pretty much to adhere to Bartolomeo, but they got so tired of reading our briefs that they eventually decided that they would overrule Bartolomeo. And so we finally got People Against Bing in 1990, and in Bing, the court simply said Bartolomeo is unworkable. We are doing away with the Bartolomeo Rule. Well, that left the question of whether they were also doing away with the Rogers Rule, but the court made clear in Berto a few years later that the Rogers Rule is still good law. So that means that we worked from 1979 until 1997, and we ended up exactly where we started. The Rogers Rule is now and still the law of New York. If the defendant is in custody on case A, you cannot talk to him about case B. People Against Paquette is worth a look. Paquette is the great Brooklyn-Manhattan case. The defense attorney represented defendant in Manhattan on a relatively minor charge, a drug charge, but the drug charge was thought to be connected to a Brooklyn homicide. And so the Brooklyn police wanted to talk to the defendant, and the defendant's out on the drug case. The police say to his lawyer, we're thinking about talking to him on the drug case, and the lawyer talks to the defendant about whether he'll continue to represent the defendant, and one of the detectives overhears the lawyer saying, I'm not crossing that bridge. So the lawyer declined to come to Brooklyn. The defendant had little choice but to come to Brooklyn, and they talked to him about case B, having taken him into custody on case B, and pursuant to the Bing and Berto rule, that did not trigger the right to counsel. The statements that the defendant made were admissible. I don't know if he filed a grievance against his attorney or not, but the attorney certainly didn't do a very loyal job. One exception to the retreat to Rogers has been noted by the court. In People Against Lopez, the defendant was incarcerated in Pennsylvania, and the New York police went out and talked to him there. They knew he had a pending case. They didn't know if he had a lawyer. He was in custody on the Pennsylvania case, which we'll call case A, and the police just didn't know he had a lawyer. The court said, look, he's in custody on a pending case. Any idiot would know that he probably has a lawyer, and the fact that you didn't even ask him means you're going to be chargeable with knowledge that he did have a lawyer. And so Rogers applied in that scenario, even though it wasn't clear to the police that a lawyer was present. And there's one other rule that's pretty clear after Berto. You can't talk to the defendant about case B, on which he was rearrested just now, after having been released on case A, if you're going to intertwine your questions to gain leverage over the defendant. So if you say to him, hey, we know you did case A, we got witnesses who say you did case A, those same witnesses are helping us out on case B, that's no good. He's got a lawyer on case A, even though his admissions will be in case B and he's in custody on case B. You can't use those admissions because of the intertwined nature of the examination. The appellate courts have also not clearly stated the answer to one question, and that one question is this. If, as per Bing, the rule does not apply when you're released on case A and rearrested on case B, What if you're rearrested on case A instead, like your bail is revoked and you're locked up? Now, logically, I think the Rogers rule will apply because you are once again in custody on case A, but you were released, and who knows if that's going to make a difference if it ever comes up. And the several cases listed here, Lopez, Stewart, Acosta, and Napier, at least touch on that scenario. And finally, the Court of Appeals has made clear that your representation in a civil case, even if it's a related civil case, has nothing to do with your representation in a criminal case. And so having a lawyer who's fighting the civil aspects of an automobile accident doesn't mean you've got a lawyer if there comes to be a criminal charge against you on that automobile accident. You've got to invoke or hire an attorney for that case separately. And just a few extra things, miscellaneous developments. You know, most of this has not been modern, up-to-date law. I've been talking about 1997 as if it were recent. But that's because this area has been pretty well settled since then. And I bring up these things to you today just because, as I said, as we go on and as we think about Miranda a lot, we tend to forget the right to counsel. But there are a couple things that are a little odd, and a couple of them are more recent that I wanted to talk about. There are a lot of Article 10 proceedings. I don't know if everybody knows what Article 10 proceedings are. They're kind of preventive detention, locking somebody up because you think he may commit a crime someday. And it applies to sex offenders who are considered to be dangerous and likely to repeat. The right to counsel does not apply to Article 10 proceedings as to statements made to psychiatrists, for example, even though the defendant can be locked up as long for the crime that he may commit someday as he's being locked up for the crime that he committed yesterday. People Against Washington, and this is by one of our speakers today, Judge Leventhal, addresses the right to counsel in connection with chemical breath tests. I'm not going to talk at any length about that because this, of course, is right to counsel as to statements that we're talking about. But if you have a breath test question, and the question is, when does the defendant get a lawyer to make his decision about breath tests, then the Washington case is one you want to take a look at. Bout is another one of the family cases, but this one involves not mom or dad coming to the precinct. This one involves the defendant calling out. The defendant called his wife after he was arrested, letting her know, I suppose, that he wouldn't be home for dinner. The defense argued that to call the wife was really a conduit to a lawyer. But the defendant never said anything about a lawyer to the wife. The wife never did anything about getting a lawyer. And so the court rejected that, I guess basically factually at least, saying that just to call your wife is not the same thing as invoking your right to counsel. And finally, we'll have lots of time for questions. Barry can get some too. There are a number of cases that, again, are beyond the scope of this discussion because they don't deal with statements. These deal with the right to counsel when you are being placed in an identification procedure. And the rules in New York are set out in cases that developed over the years, just like the statement cases did. And a good several examples of them are listed here at page 7 of the outline. And let me ask now if anybody wants to talk to me. I've got about 15 minutes left if you do. Anybody got questions? Yes, sir.
Wait for a mic. We'll get a mic over to you. Mike?
How you doing? Steve Rosado. My question, because I mentioned, you mentioned the fact that the Court of Appeals said you could evoke the right of counsel if you have a civil attorney handling a civil case that doesn't apply a criminal case. But what happens if your attorney is a general practitioner and they could basically they could be CGA or 18B assignments, but they also handle civil cases?
Well, if your attorney represents you only in a civil case, that does not spill over to a criminal case. It doesn't matter that the attorney, like all attorneys, I suppose, is legally entitled to appear in the criminal case if he wants to. Simply having him in the civil case doesn't mean the police can't talk to you. You've got to have a lawyer in the criminal case before that would happen. Does that make sense? Well, whether it makes sense, is that clear? Okay. I see one way in the back.
We got him. I don't think the mic is
Yeah.
on.
It's a Trump microphone.
Let's not go there. Let's not go there.
This is rigged.
Very nice. Under Augustine, he said that counsel, the right to counsel attaches on entry, not assignment. But assignment implies that an accusatory instrument has been filed, so that once the accusatory instrument is filed, but there's a break in time between the filing of the instrument and the assignment, the actual assignment of counsel, does not the right to counsel exist at the prior to assignment, but after the filing of the instrument?
Yes, Augustine does not talk about whether an instrument was filed. I agree that it makes sense, down here in the city at least, to think that nobody's going to be assigning a lawyer until an accusatory instrument has been filed. And you're right, if the instrument has been filed, that's a separate trigger, and the right to counsel would attach. And also way in the back.
To hear what your take is on the practice being utilized by the Manhattan District Attorney's Office and the Queens District Attorney's Office in terms of them shuttling defendants after arrest straight into their ECAB interview rooms before assignment of counsel or entry of counsel, and how the court views that.
Well, I can tell you how I view it. I don't have a problem with it. I will also say that it's been over 6 years since I had any responsibility for anything that the Manhattan District Attorney does. It seems to me that if the police can talk to a defendant, and especially if the police aren't going to put it on videotape, it's totally understandable that the district attorney, acting effectively as the police in this instance, would want to collect the same kind of evidence. You can always talk to the defendant about how you're just giving him a chance to tell his side of the story. We all know that that's not what they're really doing. I will say in defense of Manhattan that they did not employ the kind of techniques that were employed in Queens until the, I guess, Court of Appeals, maybe just the second department, I forget which. I guess the Court of Appeals said that they couldn't use those efforts to soften up the defendant before giving him his Miranda warnings. But it seems to me that there is nothing doctrinally unsound about the prosecutor talking to the defendant before he's taken to court. Now, obviously, too, if you have an extended delay, even though that wouldn't cause the right to counsel to attach, it would factor into a voluntariness assessment. And it can take time, of course, to talk to the defendant at the precinct, to give him a good night's sleep, to bring him down to ECAB the next day, to find an ADA who's not on trial. I mean, these things can take time. But I think only voluntariness components would be involved.
Up there?
To the best of your knowledge, are there any ethical consequences who initiates ex parte conversations with a defendant who was represented by counsel on an action? The defendant is sentenced, the prosecutor sends detectives to visit him in jail to talk tangentially related. He's in jail that he had counsel on.
Well, tangentially related. It seems to me it's either related or it's not related.
Charged with multiple cases in Kings and New York County.
Well, if he's charged with those.
It was prosecuted on an indictment in New York County and included incidents that occurred in Kings County. He pled guilty to one count relating to an incident in New York County. There were other incidents in the Kings that were on the criminal complaint in Kings County for which he was never indicted and never charged, but he had retained counsel, and what the prosecutor did was wait about 1.5 years while he was in jail after he was sentenced, then go visit him to talk to him about the Kings County cases.
If you assume, as a matter of fact, that it's the same case, because it was included in the Manhattan Instrument, then it strikes me the West rule applies and you can't go talk to him. Are there ethical implications to it? It seems to me in this area there are enough questions about whether it's a related case or not, and so on and so forth, that I can't imagine there being an actual ethical procedure in something as maybe unsettled as that. I can even see somebody disagreeing with me and thinking that there is no right to counsel there. And if there's no right, then certainly there wouldn't be an ethical violation that I could see in doing it. So I guess we don't know. I wouldn't think, though, that a prosecutor has to worry about ethics there.
I was curious, the separation between civil and criminal, how would that apply if a defendant in custody had an upcoming sex offender registration hearing and was assigned counsel on that? Because they're technically civil, but they're an outgrowth, but it stems from a criminal conviction.
Well, I don't know of any case on it. We do, of course, have the Article 10 case that I mentioned, where the right to counsel would not prevent you from being questioned in the Article 10 proceeding. I think if a court wants to treat SORA as really a civil case, the same rule would naturally follow. I'm not sure I think that made any sense. Whether it's technically civil or not, it strikes me that it's a natural outgrowth of the criminal case. But that's only in my courtroom.
Ed, there's a question.
Hi, I had a question about the federal rule. People v. Arthur and People v. Pinzon, when the right to counsel attaches when the lawyer knocks on the precinct door or on any door. You had mentioned that there is no indelible right to counsel under federal rules, but if in federal, do you know what the rule would be if a lawyer actually did knock on a precinct door?
Well, I certainly know from Edwards that when the defendant invokes, you have to leave him alone before he changes his mind. I have to assume that the federal rule is the same here too, but I will acknowledge that I wasn't looking for federal law in all of these areas. But I have to think that if a lawyer shows up, that's got to be it.
I have a question about a lawyer entering a case. Can a lawyer do that sort of proactively before a defendant is arrested, or sort of just notify the police department, if you ever lock up my client? Well,
I would say no to the latter scenario.
okay.
If you do have a particular thing that you know is being investigated, and you tell the police, don't talk to my client about Operation Zebra, then it strikes me that it's a perfectly good invocation. There are any number of invocations in the cases that precede custody, and so as long as the other particulars are satisfied, such as it being the right police department, such as you being somebody who actually is representing the defendant to his knowledge, and so on and so forth, certainly you could do it in advance that way before the police ever try to talk to him. Anybody else? Well then,
Thank you. Question about the West situation. Let's say it's not 3 years that have passed, but it's 23 years. It's a cold case. And you look at the cold case file and you see that when the suspect was originally questioned, he invoked his right to counsel. No counsel entered the proceeding, but he invoked his right to counsel. The police did not go forward with an arrest. He was released, and then 20 years, new evidence, and the police want to speak with him again.
It seems to me that what you've outlined is a Cunningham situation, Cunningham-Skinner, where a defendant who merely invokes the right to counsel but is not represented can change his mind. And so if 20 years later the police say, hey, for old time's sake, we always wanted to know, did you commit that crime? And he says, yes, I did, that seems fine to me. If he had a lawyer, there's nothing about West, which we thought was extravagant for 3 years, there's nothing about the rule and the principles that they announced that wouldn't apply 20 years later if you actually were represented by counsel. Now, it could be after 20 years that the lawyer has passed on, or who knows what, and those complications would obviously create issues for the court. But assuming the lawyer is still practicing, I can't see a valid way to distinguish West now that West has said what it did.
Thank you.
One more. Yeah.
If someone was represented by counsel and the case got 343'd, and now they re-investigate this, do they have to find that? Does it have to apply?
What's 343'd?
If it declined to prosecute?
If he was represented on the case and they reinvestigate the case later on, the right to counsel would still apply. He's represented on that matter, and they can't just throw it out the window and then reinstate it the next day and thereby do away with his representation. Okay, thank you very much.